flight data recorded and from other sources. We will interview the pilots just to get a clear understanding of not just...
So there was no interview of pilots before?
No, because the information we had to us was, while it was a significant event, there was a wind shear and it substantially affected the climbing capability of the aircraft. It was within the normal parameters. That's what we're trying to establish by...
What does within the normal parameters mean? There's
provision within the operating procedures for an aircraft to deal with wind shear on takeoff, Senator. And a set of procedures that are put into place if an aircraft encounters at that crucial phase of flight, encounters wind shear. And our understanding in the initial stages was it fitted within those operating procedures. There was a substantial reduction in the climbing capability of the aircraft for a period of time, but the aircraft always had positive climb, was our initial understanding of the event. We're confirming whether or not that was the case, and we hope to conclude that investigation within the next week or so.
So, I'm given to understand that a normal rate of climb would be about 2,000 feet a minute.
Between 2 and 2.5.
Yep. This was climbing at less than 10% of that capacity. Is that within normal acceptable?
My understanding, Senator, is that it would have been at approximately 25% from what we have available to us. So there was a significant diminution of the climbing capability of the aircraft.
So you say 25%. If it was at around 10% or less of the capacity, how would that categorise that event?
There's a point, Senator, clearly where I'm not quite sure this is a matter of degree and always will be. What we are looking at the moment is to try and establish what is reasonably manageable, i.e. what would be safe operations in these challenging conditions, and the extent to which there remains a risk that a really significant wind shear could lead to either no rate of climb or perhaps
drop.
Remains a potential hazard. So that's part of the context in which we're looking at the details of this particular one. But the information we have at this stage is, while there was a significant degradation in the climbing capability of the aircraft for a period, it was within what one would reasonably expect were one of these wind shear events to occur. It was handled within, so it's an extreme event. It would have had fairly extreme consequences on the aircraft, but it's the sort of thing that the normal procedures envisage and that crews are trained for.
So how do you categorise events like that? If it's within the normal parameters, then it's not an investigation, is it?
We would, in those circumstances, Senator, depending on how our initial assessment of the information went, either deal with it as what we call a factual investigation, which is we would record in detail and confirm the facts of the event and publish that and use that in future as one of a potential series of trend informations, so we could come back to it in due course if we saw there was another. So we would essentially position it so that it was there for us to refer back to on the basis of establishing a pattern of event. If we, on a risk assessment, considered it to be more serious as an individual event than that, then we do a full-blown investigation. We're always making decisions based on initial reports as to likely significance, whether we should gather further information, investigate and so on.
I'm wondering whether in a case like this where there is substantial effect on aircraft, whether you might proceed down the path of investigating the available weather information present in the tower and on the flight deck of the aircraft, in terms of whether better could be done with the information which was available, whether the information that should have been and would have been available was available for or used by persons in either of those locations at this time, and making some finding as to advisability of flight in certain circumstances.
What I can say at this point, Senator, is part of our inquiry is to establish the situation in relation to weather forecasting and availability, and particularly the question of overhead thunderstorms, as was the case in this event. So available weather information and what that might mean in terms of risk factor is something we're looking at.
But in the first instance, that is not something that you would have done.
In the first instance, Senator, we received a report which we have satisfied ourselves was the report lodged by the pilot, passed on to us by the operator, that positioned this as an event which, although significantly uncomfortable, was within normal parameters. So it was a reportable event, but not one that was saying something really, really bad happened here. So that was the initial point. If there had been a different sort of report from the operator, then we would have given it a different level of attention.
So where does ATSB get its expertise in these fields? Do you have staff who are experienced high-capacity pilots, etc.?
One of our challenges in staffing, Senator, is retaining pilots with high-capacity jet experience. We can't quite play the same rates as they can expect in operational roles. But we do have several staff members with high-capacity jet experience. We also have air traffic controllers, including those with military air traffic control experience. And we've got, in fact, the set of information that would let us make an informed decision about the circumstances at Darwin.
Which sort of begs the question, and you may not want to answer this, do you have capacity constraints? In other words, do you need more capacity? And is the workload of ATSB, is there any change in the workload? Are there more incidents, less incidents? Have you got adequate staff to look down every rabbit warren, as it were? Or would it be helpful if you had more staff and perhaps more budget or whatever?
I would never say no to more staff and more budget, Senator.
But is it justified by incident increases or? Over the last few years, there has been a substantial increase in the level of activity in the aviation sector. The level in terms of the number of occurrences reports we receive and those that we classify as having a safety element to them hasn't changed very much over the last few years. So we're looking at essentially the same number of things that we would have the potential to investigate. The picture is distorted because when the organisation started in its independent status, it had a substantial overhang of older investigations. So we had a backlog, if you like, and a fair amount of our resources have been devoted to clearing that backlog, which we've almost completed that. There are a few very old reports that will shortly come out that will conclude that process. Having done that, we are looking at the best way of taking what will always be limited resources and allocating them to those points where the most significant safety benefit is likely to accrue from investigation. It means we will occasionally look at an interesting rabbit burrow and say, from a perspective of learning something to the benefit of safety, we won't go down that one. If I had more resources, then I might take a different view. There's always going to be a balance between available resources and things we look at. Back to you, Senator O'Brien.
No, that's all on it.
Mr Dolan, thank you for coming back. I think it's the third time for this inquiry, but I appreciate it. I think the committee does too. Just wanted to go back to this this issue of resources and also experience. How many ATSB staff would have experience in high capacity regular public transport operations?
I have to confirm that number, Senator, but I think we have either 3 or 4 at the moment.
And how recent would that experience be?
It would be somewhat dated now, although we attempt to give our people some experience, at least in the ground school side of modern aircraft operations. So I try to keep them up to the mark, but recognising that we can't maintain them to the actual operational level required to actually fly those
you could take that on notice in terms of that.
Yep.
Could I just go, before I go back to the wind shear incident involving the Jetstar plane, but Senator Heffernan asked you some questions about the whole issue of show cause notices. I think, and I wasn't picking up on the word egregious, it's a strong word to say egregious. I think you said that to get a show cause notice could be either an egregious lack of compliance, or how would you define it from your understanding?
I'm hesitant to go too much further in this, Senator, because it's not my responsibility. What I was trying to say is there's the end game of a show cause notice. Show cause why a permission to do things within the aviation system should not be taken away from you, which is what a show cause notice is about, can be driven either by a one-off but highly significant issue or by an ongoing series of failures to comply with the provisions of the system. So if it were a one-off, that was the basis on which I was using the word egregious. It would have to stand out in a quite negative way, which is my understanding of egregious.
And because this committee needs to make certain recommendations and presumably will be at least looking at the interaction between CASA and the ATSB in terms of levels of cooperation. I'm not saying that you're not cooperating with each other, but in a statutory sense, if a show cause notice is issued, and you think you've indicated that you regard a show cause notice as something very serious, I think for the benefit of Hansard, you're acknowledging that is the case. Yes.
Yes. Obviously, different permissions have different consequences within the system, and a show cause notice to a major operator is a bit different to a show cause notice to a pilot operating a single aircraft somewhere. So, in that context, I would certainly say that were the case.
Currently, if a show cause notice is issued by CASA, because it's not your role that's not your statutory function, are you made aware of a show cause notice being issued? In a formal sense and in an informal sense? What are the protocols?
In a formal sense, there's no explicit provision for exchange of that information, Senator. What happens on a more informal basis is there are several circumstances where CASA as a regulator may be looking at a particular operator and we may be investigating a particular event. And so that those two things, while being independent and us maintaining our no blame role, so that they can not interfere with each other, we try and inform each other within the limitations of our legislation about what's going on. It really has to be done on a case-by-case basis. We don't want to interfere with legal responsibilities, but it's helpful for me to understand when those cases where we're investigating something where regulatory action is imminent.
So it's not unreasonable if a show cause notice is issued by CASA, from your point of view, for the ATSB to at least be aware of that, and then you can weigh up the relevance of that show cause notice in the context of anything that ATSB may or may not be investigating.
It's relevant potentially relevant for a number of reasons, Senator, one of which is it is going to have, if you like, a chilling effect on our capacity to interview those involved. Even though they recognise that we have a responsibility to protect any information that's given to us, if they're in parallel under regulatory attention, that may have placed some limits on the amount of cooperation we're likely to get from individuals.
Sure. Just wanted to go to, Chair, I've got two other issues. One, I might need a moment to speak to my office about because I've received